All right, welcome everyone. And I'm going to mute and unmute so that I won't have all this background, y'all. I'm trying to chomp something down and have this meeting in my break time. Thank you everybody for joining us today for our subcommittee to study amendments to Rule 1.19 of the Rules of Professional Conduct. I know you all have been missing this meeting or us convening to get together and talk about this very topic. So let me first start with members of the subcommittee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. So please let us know if you have a conflict. Let us know at that time because we haven't heard anything about any before. Forgive all my flyaways going over here. All right, so again, welcome everyone. Thank you for joining us via Zoom and during this particular time period so that I will be able to be at this meeting with you all today. So we will start off with approval of the December 13th, 2021 subcommittee meeting minutes. You all should have gotten those in an email. So if I could entertain a motion to approve those minutes at this
very
time.
quickly.
Motion to approve.
Wait, hang on. There is one point in the minutes where Brian is referred to as Ms. Oten. I think given the topic, we should probably correct that.
I don't believe that is Brian's preferred pronoun. You are correct, Matt.
No.
All right, we'll fix that pronoun.
And I do want to compliment Ms. Bannon on the tongue-in-cheek sarcasm with which she wrote the minutes. Very, very enjoyable.
Thank you, Mac. That's how I approach most of life.
All right, Mac, thank you so much. With that one correction, do I have a motion to approve the minutes with that correction?
Motion to approve.
Thank you, Gina.
Second.
And second by Mac. It has been moved and properly second for us to approve the December 13th, 2021 subcommittee meeting minutes with that one correction. All those in favor, please say aye.
Aye.
Or raise your hand, that's fine too. Any opposed, say nay or thumbs down. All right, I think we're good. All right, so now we're going to get into continued discussion of the draft amendments to Rule 1.19. I know Carmen and Brian have a lot to cover here. I will let you all know, just kind of, and jumping ahead a little bit to forecasting for next meetings. We're hoping to see how close we are to finalizing, or if we have finalized things to a point to where we can go ahead and push this along. And so please, I hope that you all are working today with that mindset. I know that you come to the table every time with that mindset, but we really want to try to do that today, especially because we have met quite a bit on this, but hopefully we've gotten to a point to where we can push this along. But we'll start first with Carmen, further refinements to the definition of sexual communication, scope and application, and then should the definition of sexual relations be amended. So I'll kick it over to you, Carmen.
Thank you, Your Honor. I will, Brian, if you will allow me to share my screen, and we can look at these, we can look at our current iteration.
All right, you should be good to go.
Okay. All right, so this is where we are. You should have received this document in your materials. Can everybody see that? Okay. And again, I just started with a little orientation, a little history as to where we started and where we were in our last meeting, and then the changes that have been made since the last meeting. Now, I have these couple of asterisks here for an item that is a little bit lower down in the agenda, and that was just that occasionally during conversations about this, there have been, there's been some suggestions, should we look at this definition that exists in our rule of what constitutes sexual relations? So we hopefully will look at that today and try to make a decision about whether that's something that the subcommittee wants to tinker with, or if we are okay with it as it is. But we'll come back to that in a little bit. Getting into just the real kind of drafting points. The first thing that we addressed since the last meeting was just some cleanup on how we wanted to define sexual communications. And unfortunately, I think the clearest way to do it was to break it down into a more specific definition. So I think Catherine had asked last time, as drafted, would this really actually even capture an in-person conversation? So in order to make sure that it did, instead of just capturing transmitted digital communications, we just added what is now paragraph B1 and then refined what is now paragraph B2 to be very clear about the fact that a lawyer would not violate this rule simply by virtue of receiving some unsolicited sexual content from a client. So those are the first two pieces that we changed. And then the only other edits you see in this entry on the table for subparagraph B this is just a restatement of the most important exception we've got here, which is that any communication that would otherwise seem to meet this definition, but is actually germane to the legal matter, is exempted and that's not what we're talking about in this rule. So I guess it might be easiest just to take these one at a time. So I don't know if subcommittee has any further thoughts on subparagraph B.
So if anybody has any thoughts on that, if you want to, I'm looking up here, if you want to raise your hand or either just unmute, because I think it's not a huge number of us. If you want to unmute and just speak.
All right, well.
If not, we're going to take that we're okay. Mr. Davidson.
Yes. Hold on. Okay, I'm off mute. The requesting or participating in sexually, what about fostering sexual explicit conversation? Because, I mean, somebody could, I've heard of clients, of course, coming in and showing just off the, after they've gotten comfortable with the attorney, showing explicit photos. And that's not participating, but if it's one-sided, of course, but what about fostering?
Would you suggest that in lieu of participating, or?
I don't know what you think. I mean, because you've heard stories, and I mean, I do family law, and of course, I've just heard stories and seen things that it's been a little scary, where somebody's it's not even a part of what they're there for, but they're showing explicit pictures to the attorney.
Daryl, I think that was one thing that Carmen and I were talking about, that we wouldn't expect this rule to extend to the lawyer that had a client that came in and started offering that type of those types of pictures, and the lawyer's like, hey, that's not participating. I think participating is kind of reciprocating.
Because as you know, I mean, sometimes what the client says is a lot different than what the truth is.
Right.
And, he had me show this or whatever. And, if they show it, but the attorney doesn't foster or continue on, then the attorney should be absolved from that. You see what I'm saying? You see what I'm saying?
Yes.
Okay.
Yeah, we did. We talked about that exact scenario.
And I apologize for not being part of it. I missed the last meeting.
No, that's exactly, we were talking about that exact situation. We're just debating what word do we use to try to make clear that obviously the lawyer can't be responsible for what the client may initiate that is inappropriate.
Okay.
I also think it's covered in that piece at the bottom, that communications that contain nudity or sexually explicit content but are relevant to the client's legal matter and are made in furtherance of the representation are not sexual communication. It kind of clears that there too, or makes it more clear.
Okay.
All right. Well, unless anyone decides you want to come back to that definition, it's going to look here. Subparagraph C has really not changed at all, except to include the word request. That seems to make sense in that one of the scenarios that actually brought us to even have this subcommittee meeting was the situation in another state in which a lawyer was requesting topless photos from clients in exchange for a reduction of fees. Now, presumably that lawyer would have taken the full fee minus the topless photo. And in that case, the lawyer would only have requested that kind of communication, would not have actually required or demanded it. So it just seems like that paragraph was adjusted just slightly to make sure that it covered everything that at least many members of the council seem to think should be prohibited somewhere under our rules. Any thoughts about that one?
I was just going to suggest, Carmen, I think that word relations, yeah.
Yes, I just realized that. That was another thing that Brian and I just sort of did on our own, was adjust. I forgot about this at the beginning. Was adjust these terms at the top. Sexual relations sounds really antiquated to me. It doesn't sound like a phrase that people use anymore. And I'm all in favor of plain language. So if we just decided there's no harm in changing this to activity as opposed to relations. So yes, that would be changed also. And then the last section, and this was the one that was the least fun to consider. This is where we're trying to set the scope in a way that was relatively easy to understand, that captured people who are at the stage where they are not yet clients, but they are consulting with a lawyer about the possibility of becoming a client. We realized that trying to tie that to the definition provided in the rule on prospective clients got really clunky and cumbersome, and there's really no necessity that we do that. So we just fashioned a new kind of category here, as a person or entity who is consulting with the lawyer about the possibility of forming a lawyer-client relationship until the point at which the lawyer declines the representation. Because one of the very legitimate points of discussion last time was, when does a person who came in for a consult no longer fall into this category? If the lawyer and client just never talk, or potential client never talk about it again, when does this rule stop applying? And so the easiest way to draw that line would just be to say it's whenever the lawyer declines the representation, communicates to this person, there is not going to be a representation. So we applied that, we put that language in here. And then we also tried to deal with the notion that there are certain people who are closely connected to a client. We were specifically, I think, thinking of like parents of juvenile clients, certainly some representatives of organizational clients, and that those people should also, I think the notion was that they should also be covered by this rule. And so that's how we got to what is currently these subparagraphs B and C under scope. So we would love to know what you think about that. That was a kind of a difficult one to wrestle with.
All righty. Are we all, this silence means we're all okay with everything? Or are we trying to, okay, good, Gina. Mac, I don't see your face on my screen, so let me.
I don't have strong enough internet service to have both you on the screen and me on the screen.
Oh, I was
And-
saying because I didn't have my screen pulled long enough, but what I meant is I didn't hear you or see you. So am I taking your silence to mean that you're okay with it?
I think so.
Okay.
I
I
can't
know we
think of a
did a lot
criticism
with
of
this
it.
one. Mhm.
Yeah, there's nothing about it I would criticize. I think I like where it landed.
Perfect.
And we know the reality is, even if this goes to the ethics committee, then we've got 30 or 40 more excellent legal minds who are going to want to tinker with it anyway. So, the perfect is the enemy of the good. And so if Mac is happy, then I'm going to keep scrolling down. So again, just looking at this right column, really not a lot of changes here. We realized that there was an inconsistency between some of the paragraphs that didn't capture that category that I was just talking about of people in the consultation but not yet client phase. But that was fairly easily remedied by just adding or consultation to the 2 paragraphs of the rule that make very clear that if the relationship between lawyer and this person already included sexual communications or activity, then carry on. That's not what we're here to regulate.
Carmen, quick question.
Yes.
Is consultation a defined term in some other place in the rules?
Yeah, sorta, like in the comments, probably to rule 1.18, I'm guessing, kinda vaguely. I think here we were really trying to use it more as a reference back to this language. But I mean, it's the only real definition that we get when we're talking about prospective clients under Rule 1.8 is the statement that unilateral, uninvited dump of information to a lawyer by some person out in the world does not make that person a prospective client. We do know that there it has to be a mutual conversation in order for it to in order for the rules to be implicated, I guess. That is not here, but that's really all I know. Brian, can you think of any other definition of what a consultation is?
No, I mean, and this is where, well, for one, no. As far as just a strict consultation means this. You have, like you were saying in 1.18, the rule starts off with a statement that a lawyer who consults with a lawyer about the possibility of forming an attorney-client relationship is a prospective client. But like Carmen said, we felt like we needed to get away from that, because once you're a prospective client, you are a prospective client, at least to that matter, kind of indefinitely. A lawyer will have a duty of confidentiality with regards to the information that they provided to you, or the prospective client has provided to you. So I think just as far as the consultation referenced in I guess, what is this, C2 and 3, it's really, or D2 and 3, it's supposed to refer back to the time frame we were talking about in D1B that Carmen highlighted there. If there's a better way, if that's confusing, or if there's a better way to do that, I think we very much open to that.
It wasn't confusing. I just wanted to make sure that if there was a definition somewhere of consultation, that we're using that word in the correct context here.
I think we are. I do think that we are using it consistently with how it's used in the prospective client rule.
Okay.
But it is clearly 1.18 just imposes some additional considerations for that term of our prospective client. And that's
right. Frankly, I just don't like cross references. I think they make people less likely to read to the end. And if we can just say what it is, I think we should do that.
And I wasn't suggesting a criticism. I was asking an ignorant question.
Not ignorant, not at all. This is good practice. I have exam review with my students today. So just random questions about rules that I never look at is it's a good warm up. Appreciate it. All right. So it sounds like there's not much feedback or controversy over the pieces that we did make adjustments to. So then the last item on the agenda in terms of textual revisions is this question. Whether our definition, and let me go back up to what our definition is, we take a look at it first. Whether our definition of what we're now calling sexual activity is good enough, whether it could be improved, what the implications of changing it would be. I will tell you, having looked at what other jurisdictions do on this topic, we have the best definition that there is among rules of professional conduct. I mean, a lot of them don't have any definition, or if they do have a definition, it's in the comments. So it's not as if grading on a curve, there's a problem with this definition. What's interesting though is I realized in really trying to study what's not on its face covered by this. I don't know if you all recall Louis C.K. and his cancellation, but that kind of conduct, masturbating in front of a client, would not technically be covered by this definition because it doesn't make any reference to touching oneself. There's some debate, I think there can be some debate about whether kissing is covered by this. And I feel like there was, those are probably the main two that really came to mind. I think that much like the term sexual relations, I think when the rule refers to sexual parts, I think what it means is genitalia, I think. So, you know, it's a little bit genteel at the expense of specificity. But again, that doesn't really bother me. And I will say, scrolling down here to some of the alternatives that I found, and again, these are not from rules of professional conduct. These are from other statutes, regulations in various states. The more specific the definition gets, the more graphic the language tends to be. I'm not sure what the prevailing sentiment would be about including, a list like this in our rules of professional conduct. I'm not squeamish. I'm just not sure that it's necessary. So but I'd be really interested to hear what you all think about whether this is something we should address or if we can stick with what we have.
I'll give you a quick comment from the perspective of a municipal attorney. When you look at the definitions in most of the topless ordinances across the state, or the ABC Commission's rules and regs about what's allowed or not allowed in a nightclub with an ABC license, the answer is that no matter how specific you get, you will have missed something. And you might as well just use the reasonably defined category without all the specific listings, because if you list everything you can think of, you will have forgotten something. So I would go with the more general definition than trying to list every possible offense. I just don't think you can do it. I've tried, and you can't.
Well, and then you also have to speculate about all the creative things that the human mind is capable of conceiving of. And I don't think any of us can hope to capture that in a regulation.
No.
I agree with that as well. And I actually think that masturbation is covered in this definition, but I agree with you that kissing might not be, but I don't really care. And I think it would be unnecessary and incomplete no matter how long our list was to Mac's point. So I think you've done a great job in threading that needle, and I appreciate the lack of the long list.
Well, and so
Carmen, isn't it true that we would also have a cause of action, so to speak, under something else without getting all specific? Usually if a lawyer is going to do this, something in this rule violation, it's not just one teeny tiny thing that he violated. It is across the board. He's done more than one client this way, multiple actions. So I think if we start getting into specifics, then we're giving grounds for potential argument.
I tend to agree. We usually either have multiple clients or multiple acts and just, instances with a single client. And yes, I mean, as you can see here, Brian and I actually did suggest one option that in some ways makes the rule less specific, by not even specifying which parts we're talking about. And I think in some ways this could address the issue of the, kissing also, because the point really, if you read to the end of the definition, the point is what's the purpose of the touching? That's always going to be the point, whether you limit it to sexual or intimate parts, or if, you want to, then there's no real debate about whether a passionate kissing was, involves sexual or intimate parts. We can just say, well, what was its purpose? What was the purpose of the conduct? Which we have to do anyway already. So I'm just not even sure why we need any specification of which parts. Some people are really into earlobes and elbows, I mean, I don't know.
Well, and I was going to say, Carmen, just to even frame that on that point, I think it's important to note that the State Bar has received complaints about people touching ordinary parts, which was clearly like of a sexual purpose. Is that accurate?
Yeah, I mean, I didn't just make that earlobe thing up, Brian. That's ripped from the headlines. Yeah. So that is one possibility that we could. Now, I think that this phrasing here that is underlined and bolded is really clunky, and I don't love it. This was when we were trying to say, like, how could we regulate Louis C.K. That was where we came up with this phrase. I'm not wedded to that, but we could look at whether we want to just strike that language out of the definition we have. Whatever you all think.
So I have a question, because when you went, what you just said about touching any body part could be an erogenous zone depending on the person themselves, right? I thought about, and I was thinking about that beforehand, but I also thought about, will this not be covered if the person, so say the person is charged, no, if the person is not criminally charged, so say the lawyer is not criminally charged for this inappropriate touching or this criminal touching of some nature, would it be covered?
Oh, I think so.
Okay.
Yeah, because I mean, most the criminal charges have to do with consent, and the consent of the client that's not relevant to this rule, right? I think there are fewer elements to the ethical violation than there would be to the criminal offense.
Right.
So
I just want to be sure of that, because I think that we should be broader in the definition than narrow, like what you just suggested, like taking out this of the sexual or other intimate part. So it would cover any part of the person's body. Because the way it's written now, it includes intimate parts of a person or causing a person. You get what I'm saying? And every area that can be inappropriate is not necessarily the intimate part.
right. So how do you all feel about that?
Yes.
I agree with taking out the intimate parts because, people will look for a way to get around, rules. And if you just say sexual parts, they can say, oh, well, I touched her shoulder, even though the shoulder is the place that really like gets that person going or whatever. I think it is better to be, more broad with it than specific in this instance.
I think at the end of the day, it's going to be on a case-by-case basis.
It always is, Daryl, and
Yeah.
these are all very, very fact specific. And
Yeah.
I will say I have received some complaints of clients who say things like, well, I could tell when my lawyer gave me a hug that he was, aroused by it. That standing by itself that's not evidence that we can proceed on. That doesn't mean we need to have actual evidence that there was that either inherent in the touching was, it was of this nature, or some specific other, outside evidence showing that the lawyer was, headed in the direction of sexual contact, that was the point. So it is always very individual when we're evaluating these facts.
Before you move, I think we need to look at editing, yes, that second part too. So to mirror, so touching of the lawyer too, to touch the lawyer for the purpose of arousal too. So to mirror the.
Yep. Look how short that is. Good for us. Any other thoughts on this? Right, well, that's exciting. It sounds like, at least when it comes to the language, we're feeling we've got consensus. And I'll just delete out all of these lists of body parts. Okay, so what do you think, Judge? Should we move on down the agenda?
I think so, yes.
Okay. Then I have one thing. So the next thing on the agenda is just a discussion about when non-harmful conduct is prohibited by the rules of professional conduct. And I've been really mulling this over because it is, Gina and I feel like having this wonderful debate, but I never quite feel like I could figure out where I was coming from. So I really tried to figure that out. And what I realized is that I think one of the questions here is what we are proposing with respect to sexual communications, is that a prohibition that is potentially making punishable conduct that is not in fact harmful? And I'm sort of swapping out the word exploitative that we've used in talking about this rule with the word harmful. So I can talk about it in general terms. So then I started thinking about the rules that we already have, trying to answer the question, is it legally permissible for a state bar to regulate conduct by a lawyer that may or may not actually cause harm? And so I wanted to show you just a little bit about what I discovered about that. And this is too much text for a PowerPoint slide, but and actually I want to do this as a slideshow. Does that show up as a slideshow now? Okay. So what I did is I looked back at the Supreme Court case in which they determined that it was appropriate and permissible for a state bar to ban in-person solicitation of clients. And a lot of the arguments in that case went to this issue of what is this prohibition, and is it necessary that the regulatory agency be able to prove harm in every instance in order to justify the rule? So I noticed these are just some of quotes from this case, and instead of it referring to solicitation, I've just replaced the phrase prohibited conduct. And what I noticed here is that the Supreme Court said that, a prophylactic measure designed to prevent harm is reasonable, and that in that case, it was also reasonable for the state bar to determine that this in-person solicitation of clients more often than not will be injurious to the client. The state bar did not have to establish that every time this particular act was going to cause harm, nor did it have to prove in each instance that harm had been caused in order to justify discipline. And what I thought was significant about that, when we're in reference to what we're trying to do here, is that the conduct that was being discussed in this Overlick case is possibly helpful. There's some interesting decisions out of the Supreme Court that talk about people who are vulnerable and don't have information about legal services, and in some cases being approached directly by a lawyer who says, listen, you might be able to sue and I can help you. That could actually make their lives better. I mean, it could improve things for them. And so, but even that being the case, the Supreme Court still said it's okay to do a blanket prohibition, because it's reasonable to assume that more often than not, this will be harmful. So I'm a very visual person. So then I had to draw myself a picture of the available universe of conduct by lawyers that would have to fall into one of these three categories. And you look at the solicitation ban, probably lands somewhere around there on the chart. So there's a significant number of instances where it will be exploitative and put undue pressure on a client, but not always. And in fact, there are some times where it could be helpful to the client. Another rule that is like that, except in my estimation, probably has a high chance of being beneficial to the client, is the rule that prohibits lawyers from giving financial assistance to their clients. So then we have another category of lawyer conduct that is across the board banned, even though there certainly is a likelihood that it would not be harmful and in fact would be helpful to the client. So then situating what we're talking about, I think it falls somewhere here. I don't think that we are going to take the position that in any case it is beneficial to the client to have someone who is supposed to be in a position of trust and a professional role blurring those boundaries. It might be neutral, but it's not going to be of benefit. So I guess my purpose of showing you this is to say, I believe that the law absolutely permits a state bar to enact a prophylactic rule, even if it may cover neutral conduct. So then the question for you all is not can we, but should we? So I just wanted to put that out there, show you what I found, and so you would have that in your minds as you're deciding how to proceed.
Any questions for Carmen on that? I love the chart. It was great for me as a visual person too.
I don't have a question. I have all praise hands for that. I mean, that was one of the most beautiful takedowns of a theory of mine I have ever experienced. So thank you, Carmen, for putting it in a visual. You've tried in about 3 or 4 of these meetings to get through to me, and it hasn't worked because it's a very thick skull, but you have now done it. I will hush. Beautiful job. Thank you, ma'am.
Well,
Gina, I have
you.
to tell you that when we talked about this before, I said, I think Gina was going to get it now. Like, I think this is the way to get the point across.
Well, no, but I also had to get it, you know, I think that was what I was saying is I felt like I wasn't, like, we were sort of having different conversations, and that's what, I mean, so that's why debate is really good. I think it really improves people's thinking. So I appreciate it. So that was all I wanted to share. Brian, is there anything that I've neglected to mention?
Not at all. I do think procedurally, if there's no further discussion, Dorothy, I think it'd probably be good to have to get a motion from the subcommittee. You'd be looking at potentially publishing the rule as amended, or the rule amendments as have been discussed and displayed here today. That way you can report that to the full committee that the subcommittee has made a motion for particular action.
That was where I was headed. I thought we were at a good place too, having not had a lot of discussion as we've had in previous meetings, which I appreciate you all. We've done a lot of work on this, and Carmen, thank you and Brian for bringing this to our attention as something that we needed to study. I think we've done a really, really good job, and my feeling is that I think that we are at a good place to go ahead and send it and make our recommendation to the ethics committee, because we all know that could invoke more discussion and it could be sent back and all of that good stuff. But I think that we are at a good place. Unless there are any other, does anybody else have any thoughts about that? If not, I would like to entertain a motion to go ahead and send this over to the ethics committee with our report and recommendation for these edits.
I do have a question.
Okay.
Are we sending it to the ethics committee for the ethics committee to discuss, or for the ethics committee to publish?
Oh, that it would, Brian, correct me if I'm wrong. It would go to the ethics committee as our recommendation from the subcommittee to publish it, right?
That's right. So essentially there's a couple of different steps. Because it's an amendment to the rules of professional conduct, your motion would go to the ethics committee. The ethics committee would then have to debate, and they would move themselves to publish the amendments. Again, because it's a rule of professional conduct, it actually needs to funnel through the executive committee. And so it'd go to executive and then the full council for publication of these amendments. So there's a number of steps that would be taken next week. But this would be the first one, I think, to come out of the subcommittee as a motion to publish the rule amendments.
Thanks. That's helpful.
But we would, of course, report at the ethics committee all the work and back and forth and discussions that we've had, so they will know just how much has been put, as they know already, because they've all probably participated in one of these wonderful subcommittees and know how we do in these subcommittees, and a lot of discussion now going back and forth. So they'll probably be grateful that we have already had all of these discussions and kind of, looked at all of that. So do we have a motion? Or are you all ready for that? Yes, Gina.
So moved.
Thank you.
Second.
All right, so we have a motion to send this to the ethics committee with our recommendation and a proper second. All of those in favor, please say aye.
Aye.
Raise your hand. All right.
Aye.
Any opposed, please say nay. All right, I think that has passed. So we will send this over, and we will say that this is it for us for now. And hopefully that'll be for good. But if not, I would be fine with seeing y'all more to talk about this too.
Well, I really appreciate all of you and contributing your time to this.
Now, what if they send it back and say, hey, you got to list some body parts?
We're coming to you, Daryl.
Hey, Mac, this has been great, everybody.
Y'all have a nice one.
I'm looking forward to seeing y'all next week.
Yes.
Bye.
We'll see you then.
All right, y'all have a good one in case I don't get to see you next week.
All right. Bye.
There. Bye-bye.
Thank you both. Thank you, Brian.